Sctnews was of the effect that if there is no certificate under 116, in Mr. Ichesa's words, the first accused is and he is not a lonely man, verbatim, if I got it right. Objecting on, is it points of law or what you say?
As in, you have quoted my statement in my presence.
Yes.
You clearly misunderstood it, and you want to go to next. Person without clarifying the court.
Sorry, Your Honor, I have not shown in my interpretation, but in hearing you, I can't be wrong. Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I am coming to the point of law. And thirdly, I am reminded that my very good friend, senior Dr. that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that of the judiciary bail and bond policy guidelines talks about likelihood. Yes, Your Honor. I am done. That is my last point. Influence, there is a compelling reason you must deny it. And standard of proof is on our probabilities. I thank you for being patient with me. I am such a mouthy, and we urge you that we have established compelling reasons to deny the certificate. Thank you, Mr. Your Honor.
Your Honor, the commission, you add one of my colleagues of here. Honorable Jeremiah Kioni, for counsel, who will listen on record. We now able to come through. Good idea.
Now, technically, you are ruling on the matter. I possibly need one, we take a lunch break. So the issues are into millions. I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to, unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by that actually can give ground for my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling. Much obliged.
La. Nimejishinda kwani uko na radio cool leo.
Ulipa huyo. Kila mtu bwana. Waziri unaita.
Kama sipo. Poa sana. Si bora kumsinde na usinde. But jua ikizima hivyo tuko na picha. Subaru, unaona ile Subaru?
What do you know about them? The last. Yes. You're right on time today. You're right on time.
Nani? Ni watu wasomesongesha tu ndio na sisi hapa na wewe.
Hata mwingine anataka kutoka lake nini?
Sasa tutakuwa sauti.
Chukua vitu vyenye unataka tupe bali ndani. Yes.
Unaita ndio ndio. Wewe
alafu ukae hapo. Naomba.
Anavuta. Number 024 of 2025, Public versus George Natembeya.
Walubengo, Waningilo.
So the last name?
Walubengo, Waningilo. They are just been served the church now. They just go on there.
Lombachi, you have not commented about the second.
Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true?
It's not true.
The payment made by county government of Trans Nzoia to Lima Agro Science Limited, Maira Stores and Easterly Wheels Limited in conflict of your public.
No, Your Honor, by the prosecution, we purport to the directions we need
We believe that because we oppose bail, and bail being ordinarily a right, then this has to go first in an application post bail. Then we take the court through the affidavit, the factual matrix. Then we take the court through the affidavit, the factual matrix. Allow me to take the court through the legal matrix. Now, I'll start by indicating that the law on bail is almost application in Article 50, sections, and that every arrested person or an accused person has entitlement to bail. I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you. If you can give, I promise they will say what I'm telling you. If you can give them a chance, the council, if you can give them a chance, the council to deliver, just a chance, the council to deliver, just speak for the state which it represents, to deliver, just speak for the state which it represents, speak for the state which it represents. The accused has sufficient defense. Accused has sufficient defense. I repeat, decorum. I repeat, that time, decorum. It is strike law. It is strike law that the denial of bail where there are compelling reasons is not a breach of the presumption of innocence. Then I trust the court to have a look at Chomley case. I'm not very good with the spelling of the pronunciation of the word. We do not have copies of that authority, but because this court has noticed there, the Chomley case is clear on the relationship between the right to bail and sorry? And the High Court level or Court of Appeal? The High Court, sorry, the High Court. High Court, yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. And the effect thereof is that the only rights cannot be limited at the rights of Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right to presumption of innocence, by denial of bail, can be permissibly limited by being Article 24 of the Constitution. The net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of rights under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya. We have guidance from the Judiciary Bail and Bond Policy Guidelines. Judiciary Bail and Bond Policy Guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an integrity of the trial before you, protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, we are releasing an accused person on bail will prejudice the integrity of the trial. we are releasing an accused person of bail, even when it is shown that they will attend trial. We are releasing them on bail will prejudice the trial, and therefore the integrity of the trial. This court has a reason, a compelling reason to deny them bail. A likelihood to interfere with witness exhibits or ongoing investigations is a high likelihood of interference with the illegal trial. That's it. Allow me to say the last thing on section 8, section 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, subordinate court's jurisdiction to enforce Bill of Rights. Questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Kula.
And we have filed an affidavit sworn in May 2025 by Mr. Robert Swan. 19th of May 2025. This morning. Sorry, Your Honor.
So that is right.
Yes, we filed this morning.
And 5.
Yes, Your Honor. It is sworn by Robert Bono.
Sworn by
Robert Bono. EACC forensic examiner. There are the factual reasons or grounds to reject bail are defined from paragraph 1, paragraph 12. However, I will cluster them into three. 1 to 12. However, I will cluster them into 3 compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the the first compelling reason, we submit that subject to this case, there are other ongoing investigations which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, attacked EACC and LPS officers in lawful exercise of their duties. This has been reported and is captured under annexure number R38 at Kitale Police Station. R38, PR38, annexure PR38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection, Your Honor, is founded on section 106B of the Evidence Act.
That is your name.
Willis Otieno, counsel for the first accused. Section 106.
Based on
Section 106B
electronic evidence.
on electronic evidence.
You get your time.
No, I need to raise an objection because it's time to refer to it.
You get your time, let it continue.
Also, we have a next
Please,
evidence.
I want to continue the direction. You can continue.
Yes, Your Honor, we have a next series of photographs marked as RR1 to RR37.
One, two, R.
37. Your Honor, those photographs depict vehicles belonging to ACC, National Police Service, that were vandalized at the residence of the accused person. When the officers were executing the lawful mandate.
Executing.
The lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
Come again. Miscellaneous application number
E716
E716.
of 2025. That is deepened in paragraph number 4. Now, photographs RR3 to RR10. RR3 to RR10. They depict motor vehicle KCH 046T.
Come again.
46T. After it had been vandalized. Then our photographs R11 and 12 depict KCD 62HX. Photograph R11 KBU 734Y. And photographs for U, ACF 541U. Run at paragraph 7 and paragraph 8. The officer depots.
Sorry.
At paragraph 7 and paragraph 8, Mr. Rono depots. These vehicles. Important documents were taken. Now we take judicial notice of the position of the first accused. The witnesses in this case, Your Honor, upon disclosure, are his subordinates. People employed under his government. Then what is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that the truth may turn up with the witnesses.
The test is
A reasonable prospect that the accused person will tamper with the witnesses or the evidence.
Perhaps, I'm aware of the directions you've given for the paper. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit that effect that the proposed witnesses are subordinates of the government.
I'll give a guidance again. Wherever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I'm wondering.
But let me record you first. Mr. Kula, give us some Any select copies of objection? Everyone,
I will repeat your honor.
how long, more? I thought we were going to take 3 minutes. Now we are very good. We sit here the whole day. Just off the car. How long more?
I'm telling you, tell me, sir. Just summarizing it.
10 minutes. Um, continue, sir.
Yes, sir. I will repeat
You
that.
have 10 minutes.
We are submitting that once disclosure is done, the witnesses will be calling our officers from the first accused, those at least availability. I'll go to the second plea. Severity of the offense. Go to the second plea. When approval of the charge sheet, the amount will appear cash.
The amount will appear.
Minimum 1 million. But we believe Your Honor will win this case, and we draw your attention to section 62(1). 62(1). In the event we succeed, that provision is very punitive.
In the event,
We succeed,
we is
the
the
DPP
DPP
prosecutes this case, we get a conviction.
is successful.
Yes. We will be moving to section 62, subsection 1. And you know that the severity of corruption cases for someone to interfere is subject to the positive. Your Honor. Lastly, I've alluded, Your Honor, to what transpired yesterday. And I've said that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday, Your Honor, we look at it. And we are apprehensive that in the interest of, in order to protect the integrity of the criminal justice processes, a plea bail court will agree before this court and decide on this matter. That will be amended.
You can this
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence you have done. Thank
You guys, how many of you please?
I'll take the first one.
Because I listed how many? 11.
Yes, and one, not all of us, not all of us, certainly.
So how many?
Just to manage our expectations.
All types of activity. We do it on the ground. You know, drama, we just want to put the issues. Because the issues are straightforward, Your Honor. But let me start by introducing Senior Counsel John Kaminwa. He's our guide.
Good morning.
So we have an opportunity. Then Aaron Duby. Aaron Duby is also here. So that is Aaron Duby. Your Honor, let me be the first one to just give some. So, Your Honor, let me at the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point should be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And then sometimes, Your Honor, as a counsel, it is factual. It is factual. Yes. When we propose,
But I'm sure Dr. Hamira is smiling at you.
when we propose,
But I'm sure Dr. Hamira is smiling at you.
in fact, I'm one of the few who have the advantage of having interacted with you in my previous question in JSC. I know you have a very sharp mind. We don't need to come here and start the previous question in JSC. I know you have a very sharp mind. We don't need to come here and start citing to you positions of law and affidavits. So I cannot, by any stretch of imagination, expect that a court.
I'm making a backup for the. We don't trust technology. I'm making a complete backup. And you can continue.
So I dare say, Your Honor, that even the prosecution, because they're also lawyers, we all pass lawyers before we.
Sorry, Your Honor. I know the court warned us of decorum, but we plead. I am just 12 years in practice. We plead that senior Macharia doesn't get personal.
There is a special reason, Mr. Njero. I did what I did to your side, so that we remain focused.
With tremendous respect, what we have here is lawfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today. And none of us can purport independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective. Your Honor, I'll make a confession to you. I was, and we shouldn't allow it. Your Honor,
Mr. Njero,
I'll give the context. I'll give the context, Your Honor.
the
Yes, I'll give the context.
focus here, Mr. Njero.
Yeah, context. I'm not here to talk about where I was.
Sorry, Your Honor.
It's just to indicate.
No, sorry, Your Honor, we are forced to object once more on the question. The factual matter is that with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that it's previously the commissioner, we understand, but let him get back to our case. Thank you.
Look at the affidavit.
A minute, Mr. Njero. I complete everything.
Your Honor,
Mr. Njero, your brief response, you're responding.
David. They've made general averments. To start with, problem number one, they serve us in an affidavit this morning. We expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, the accused. Then the affidavit itself is marked general averments. Both respondents agents, they are not naming which agents.
Oh, just to be clear, you're responding to the objection or you continue with your submission?
I'm responding to
That's
subject
clear.
averments, yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he respond to that, at least from the back. At the very least, that should be expected. He can't have a steak and eat it. The subject of these proceedings is the accused. The rest of us are speaking here, and then we'll walk away. But there's the subject. That's the person you should focus on.
On the law governing bond and rate. That is the issue on the table. Continue Mr. Level.
Much obliged, Your Honor. Now, including very sensitive security agencies. And you also understand the law by its own right. He understands his obligations to the public security. In custody for this kind of charges. Why? It can only be for, and it is that desire to continue punishing you that is driving the application for you to be denied freedom. You cannot allow yourself to be used. I have consistently said that the last line of defense for this country, the only one remaining, Your Honor, is the judiciary. And let's not think. So regardless of what happens here with these protracted submissions and responses and counter submissions, not fall under the trap of saying that you're going to write a ruling another day. In the meantime, he remains in custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court and he never appeared. One of my colleagues here will speak about the facts, Ken Chesa, but I can tell you, Your Honor, the reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Please do not fall into that trap. I'm confident you will not do it.
Thank you.
You can continue Mr. Jiro.
Your Honor, just to associate myself with the submissions made by Milimani Senior, drive the mischief. That the accused person is carrying.
Slower. Pause after every sentence.
Is charged before you with another person, Wafula Masungo, who is not before you. It is not that Wafula's whereabouts is not known. It's because Your Honor to perpetrate this mischief. In almost for explanation, Your Honor, Milimani Senior indicated that he was seeking summons. It's the same mischief, Your Honor. The opposition, Your Honor, was that you seek summons. Was not indicated to you. That is to say, you must be read in light of that mischief. That other than pursuing other ulterior motives that are politically actuated.
Apologies. Councilor Perez. You directed. Colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we would ask him to take the rights of the accused person. Let's not impute ill motive to anybody unless they are willing to test the dog. We're ready.
Is contained in the affidavit filed by the ODPP. That's not surprising, Your Honor, that the affidavit contains, it has no tangible evidence that proves to the contrary. If I was to proceed in response to the substantive application,
must give direction to the direction. And belonging to the law on bond and bail, avoid instances which may persuade me to request for fact having
the affidavit contains mere speculations. There is no affirmation in the affidavit.
After every sentence,
before you, the affirmance in the affidavit have no nexus with the charges before you. Neither the prosecution, nor the defense, nor the court are privy to. Would be tantamount or will amount to violating his constitutional rights. And most importantly, the right here are subordinates to the governor, the accused person. Again, is not contained anywhere in the affidavit. If has no probative value of whatsoever nature, and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more of KCH 046T, it will not tell you the registered owner of KAE 798F. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, as I pen off and invite my learned friends, to draw your attention to the charge sheet once again, that there is no charge where there is a charge of conflict of interests. at Article 50 in isolation of Article 25, in light again of Section 8 of the Magistrates Court Act. From Article 25, it tells you that the if you look at the law, Black Laws Dictionary, Black Laws Dictionary, it will give you as to what is deemed to be compelling. No evidence produced, no law produced, no law quoted, no case law, the integrity of the proceedings, will not affect the so-called pending investigation of open society. I invite Mr. Jero to guide us on who next. Thank you.
Another
Willis, and then we select them. We
understand the application, right?
We understand.
So you cannot submit the whole day and expect magic. We should be reasonable, and they say, my wife, Chester, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue on Section 8 of the Magistrates Court Act gives the authority or search warrants, not such warrants, which they abused by literally and Nairobi bundling him into a police vehicle, bail, to deny bail. The High Court must provide cogent, the term that is cogent evidence, and he keeps referring to some ghost creatures called agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to the so-called agents. Was it Governor Natembeya's wife? Were they governors? And this court must not listen to them. The accused person, your evil servant, he is Soya County. He is a deputy party leader. At the time, the so-called ghost agents were shouting, he was only one advocate. Mr. Smil and the rest of us were locked out. The court said that the seriousness of the offense,
I repeat, 1 is enough.
Lastly,
I don't know why we get this temptation, as the more I speak.
the High Court at Nairobi, criminal case number 48 of 2016, actual witness interference.
That indeed, as at 6:30 a.m. yesterday, the accused person had lost by Mr. Robert Rono is certainly not accurate. Number two, Your Honor, the place where they went to play Milimani residence. That is repeated as the order that they received to search the accused premises had the following residences: Kibomet.
Come again.
First is
No, I second.
second is a place called Kibomet. Kibomet. Third is Nairobi residence in Kileleshwa. Okay. Were vandalized when they were searching his internal room. Your Honor, looking at the order, which Your Honor you can have a look at. And therefore, Your Honor, we are appealing to you that the evidence that has been annexed to the affidavit is illegally obtained. 5, to the Evidence Act, Section 106, capital B, Section 4, subsequent employed.
You're on the 6th minute. The 6th minute.
I wrap up here. Please refer to the
Are you ready to listen?
I yield.
Honest to records.
Thank you.
You know, I tried to recite 3 minutes at max, and you stopped with 5 minutes. There is no certificate of electronic evidence annexing those pictorials. By dint,
Slow. You left me a mind to go. Their applications contain
and in the absence of the electronic certificate, the annexures, Section 3 of the Judicature Act, lists the sources of law in Kenya that this court is called up. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply remaining constants. The right to bail is constitutional. And the purpose of giving terms is to compel attendance. Detention should never be used as a basis to punish an accused person who is still presumed to be innocent. Thank you.
and Jerry, your last soldier. Your last soldier.
Thank you, Your Honor. Your Honor, I'm very privileged to appear before you to demonstrate that what I did recently in my second PhD in criminal justice. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ES law, whereby if the government raises its own legitimate expectation, if that was the case, then that law must be narrowly, and I mean narrowly tailored. How do we look into the classification of what the state has alleged? Classification, looking at the time to drive, the time taken to drive the accused, the miles involved in that journey, and how the accused was arraigned in court. Lastly, and please let the court make me understand, whether the arresting officer is the investigating officer and is the judge, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances. I think it should, because I can substantiate it. Your Honor, what I mean by literacy is not literary. Raises issues that can only be raised on discovery. Thank you.
My grandparents in Turkey, I always appear with very many cases. Like only one word, if you want to check that. Only one word.
The one word will take you 1 minute or less. First, you look at the charge sheet. Particulars refer to one. It is impossible to tell you which one they mean, except for the use of the word God. The latest that is the particulars in the charge sheet under the law. I make the presumption that the court knows how to do that, right, and understand. Those particulars, which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest have not been indicated. So that's what it is. If you look at count 2, the same problem of lack of particulars. So there is no evidence that demonstrates. We are told monkey see, monkey do. When the government itself mandates court orders, citizens have no reason to. I do recall off the top of my head the governor of Istanbul who was charged with that. The court has authority and discretion to give conditions that will ensure that the proceedings of this court are.
The several councils of the advocates have spoken. They have made absolute submission. I would respectfully argue that and tell the audience that a human ruling will be delivered. By the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons to venture.
Yes.
Has always been done by the Court of Appeal that the governor is released falsehood and you deliver the ruling sentence. I also argue very, very respectfully to the nation, and there's no way you can give Kenya for another country. Give them a free fall. And you will also be educating certain people and certain people, saying to you respectfully that you make an order before you rise.
Sorry, that is called, and it's
that the governor should be released on a free fall.
You're a child?
Born in the colonial days.
Colonial days.
I'm the child who received education in colonial institutions. Of sociology, anthropology, philosophy, when we had terms like the African mind, how the African thinks, and so on, from the colonialism. There's one thing I can make you very clear. The criminal law of Kenya has always, during the colonial days, it was abused during Mzee Jomo Kenyatta's stay. It was abused during the Patrick reign.
I think the statement is home, the child. The statement is home.
They have now taken over the criminal law of the country. They are abusing it. The rule of law, which we thought was improving, is now in ICU. That unless we arrest the situation, nobody will have confidence in the country. The country could easily be classified as a country that you can come to.
If we can deal with Mr. Natembeya first.
Yes. You wanna, what is that? The judges you are even here, one can even pass this class. The first comes. The governor is supposed to have corruptly received the sum of saying 1 million, and see that this is dishonest. Dishonest. The country because of that amount of money. That's on the first stage. What is that? A full governor, 2 million, 116 states. That's the honor. We were letting a point clear. A constitution to be meaningful, it must develop something called convention. In some cases, something called convention. You would expect that a charge against a governor of the country, the director to satisfy himself that a case has been made out against Natembeya. Having regard to what was being told, was realistic to him. When did the DPP read the entire file? At least if I may say in favor of Charles Njondo, he would read the entire file to satisfy himself that indeed a case has been made out millions of people. It is therefore not surprising that the people in his own area were mad to not read at all. Your Honor, may I say, draw your attention to the fact that I also have no jurisdiction in the same account that they have the government principle. There's no jurisdiction. But a charge will be filed against the governor. The way to deal with the governor is to use the impeachment procedures that have been provided for in the Constitution. The governor. One final question, one final submission and the next to you. Please, me at all. What is required of a lawyer? What is required of a magistrate or a judicial officer is to be strong and to be courageous. And imagine you very structured that rise to the occasion the country has gone down. And you need young people like yourself who have got power to see whether we can bring up and maintain that let the executive keep its own base, not to get into other days. And currently it is not doing so. Other quotas and so on.
Mahatma.
Yes, there is a book here which we refer to impeachment in Nigerian presidential system. That's why we have a lot of impeachment of governors and so on. And that's the order for this book.
What is the title?
You know, I'm taking the title. It's impeachment in the Nigerian presidential system. I assure the Milimani you have captured.
Yeah, there's a lot of issues on impeachment of they would rather die than have such a government in power. Yes, as some people, I'm sure are swearing that they would rather die than see Governor Natembeya in power.
Well, the father, the profession, he has said it all. Give the governor free board. At the very worst, so that we don't play in the hands of his tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until that effect. So let's not talk about conditions. In fact, that bit, when it is expanded, I plead with you, expand it. Let him get his free vote or cash bill, let him win. Even if we believe the runner will do the right thing. You have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law, that today George Natembeya will work out. No conditions have been sought and he shouldn't even be there anymore. Let the man go and serve. He'll have his day in court. Thank you.
So, Ian, I'll start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as to whether or not this court jurisdiction will entertain these charges. And that is related to reference, I believe. I haven't made reference, but I believe that's the position. You are in brief responses. This court's jurisdiction to entertain anti-corruption matters is provided of the ASEC. ASEC is a law. Point of law is ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings. Allow me to make two. Number one, I don't know whether counsel read the charge sheet. Count number one is conflict of interest. And not just that. Count number two. How could he have? The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't situated within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. So the arrest was proper. The searches were proper. To ensure and promote an equal application, ensure and promote an equal application of the law to everyone, of the law to everyone, equal application of the law. Article 27, sub-article 4. Equal application of the law. Article 27, sub-article 4 of the Constitution. Properly, on the basis of which on the basis of which it would institute these proceedings, before you. I withdraw.
If you have withdrawn, I wanted to clarify that.
I scored it different. So I withdrawn. Back to the question of bond as I conclude. Page 19 reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines in opposition of bail. Anyone can confirm because the guidelines are available online.
But the prosecution
Does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that we make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there's no basis. There's also the argument as regards saying that we have not.
you can't admit that know your pace, not abilities. I'm not doubting your abilities. You have estimated your pace. We can continue.
Thank you. Yona, I was referring to. Did I say last? Thank you.
Last, you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under 116 Aminwa, in Mr. Ichesa's words, the first accused is a governor of a country and he is not a lonely man. Verbatim, if I got it right. Objecting on, is it points of law or what you say?
As in, you have quoted my statement in my presence.
Yes.
You clearly misunderstood it, and you want to go to the next person without clarifying to the court.
Sorry, Your Honor, I have not wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact, points of law.
Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I am coming to the point of law. And thirdly, I am reminded that my very good friend, senior Dr. Ndu, that the influence of the first accused is admitted by his counsel on his behalf. And that it's not far-fetched that of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. Yes, Your Honor. I am done. That is my last point. Influence, there is a compelling reason you must deny bail. And the standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouthy, and we argue that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
Your Honor, the commission to add one of my colleagues who came in late. Honorable Jeremiah Kioni, for counsel, who is placing on record. we now be able to come through to do the right thing.
It's now technically you are ruling on the matter. I possibly need one, we take a lunch break. Take a lunch. So the issues are into millions. I will try the best to do it in 1 hour. I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by that actually can give ground of my abilities and competence, which I do not wish. To take a break, we resume at exactly 2 for the ruling. Much appreciated. Yes.
Sound Candy Talk Live News.